In 2011, the state petitioned for a writ of prohibition in appellate court. What does that mean?
A writ of prohibition is asking an appellate court to prohibit another court from ruling on an issue. And they did this because in this case, by losing on the motion to dismiss, they would not have had an appeal right until the end of the case. So this was the state's creative way of trying to get a ruling to avoid having to go through this case.
What was the plaintiff's position about whether the courts have jurisdiction?
Plaintiffs believe that courts should be involved in interpreting the Constitution, and it's very important that we get to the court and be able to prove the truth about what's going on in the educational system, and that's our argument, and the justices agreed with that.
What did the appellate court do?
The appellate court is very interesting because typically an appellate court is 3 judges. Well, these 3 judges asked the entire judges, and they went en banc by themselves and asked all 15 judges to rule in this case. And 8 of the 15 ruled with the plaintiff, saying that there was a justiciable issue, meaning that the courts can be involved in this and it's not a political question.
Okay, and lastly, what does it mean to certify a question of public importance to the Florida Supreme Court?
Most cases, the appellate courts decide on their own, but there are certain cases that impact the entire state or are of such importance that they want to have the Florida Supreme Court weigh in on this decision. So in this case, the 15 judges asked the Florida Supreme Court to weigh in and decide whether this was an issue that they agreed with or not.